let me return to this sort of pleasant situation that we have here today. I can imagine that you're very nervous sitting up here, and I can tell you the same for me here. It's not every day that you're chairing a panel with such learned personalities. In addition, you do not have usually an audience of 900 people, because as you know, arbitration is private. And also what you don't have is 2 bottles of wine standing on the table of the tribunal. So a thank you to the Czech team that I heard sponsored these bottles. I think it's a very nice thing, and I'm pretty sure that we're going to open the bottles after the finals all together. For me, it's also already won. Both teams have won, and all of you have won because you have participated here. You made it to the finals. I think you should all take this opportunity and make the best out of it, and I really congratulate you already now that you have come that far. Well, having said that, I wish you both the best.
The hearing, the claimant will begin again with the issues of damages for the framework agreement and document production request. In the case of the claimant for 14 minutes, in the case of the respondent for 15 minutes, leaving both parties 1 minute for rebuttal and sub-rebuttal.
Okay.
Costs are damages under the CISG and the requirements are met. The submission of the claimant here is that this costs are indeed recoverable because there is no res judicata issue. Well, we can take different approaches in this hypothetical situation. The first approach is that in accordance with Professor Falamegas there.
I mean, you just could have answered to the letter that was sent to you.
I understand your concern, Madam President, and the opposing counsel may bring this.
Which is the legal costs incurred by the claimant in prior sets of proceedings. I'll speak for 13 minutes and respectfully reserve a further 1 minute. A competent sovereign court, the Mediterranean High Court, has already ordered the claimant to bear its own costs in prior sets of proceedings. The only reason why we are discussing this before you today is because the claimant seeks a second bite of the cherry and is claiming the exact same sums as damages under
recovery of attorney's fees. That is, it seems to be a matter of treaty obligation. I just wondered what is lacking in attorney's fees to satisfy the requirements for recovery under Article 74.
Certainly, Professor Flecht, and if I might go further than that, perhaps there's also an issue.
And were caused by the breach. Would you still argue that they were not recoverable under the CISG?
Yes, Professor Flecht, we would, because we would say that allowing the recovery of attorney's fees would contradict the procedural laws of
to the case that we are dealing here, and I'm pretty sure that you are familiar with the STEMCOR versus the Alacero case, and I would be much more interested to learn why you think that we should not follow that reasoning.
Well, that the principle of equality extends also to claimants and respondents.
Does that mean claimants can never be entitled to recover any damages because respondents can't have a claim to damages?
No, Mr. Bond, we will not go so far, but we...
Your counter-offer.
Certainly, and this relates to my final submission on the declaratory proceedings. Our argument here is premised on Article 80 of the CISG, that the claimant is precluded from claiming the cost.
I think 1 minute of rebuttal, please.
Thank you. Respondent's defense on the non-liability action is based on
are most likely to be higher than the gains made in the respondent. Now regarding the first point, there are 2 underlying factors.
Counsel, just what would you identify as the basis in the CISG for the remedy of disgorgement that you propose?
It says, how is the claim for lost profits in Procedure Order Number 2, Paragraph 5.c to be understood? It covers the delta between the price claimant would have paid for 5,500 bottles, that's to say 41.50 euros, granted to the breaching party who failed to comply with its obligations with the claimant, or to the party who suffered the damages because it could not comply again with its own customers. First of arbitration is consented. The parties can exclude discovery. It is not a mandatory right as for the parties to present discovery. However, this exclusion does not reach the possibility of requesting documents under the and for this tribunal. We could move to the Article 8.2 and the objective test. What a reasonable person would have understood under the same circumstances.
Can you remind me, is there evidence in the record of your client's
Indeed.
First issue of the disgorgement of profits. Counsel for the claimant has suggested to this tribunal the only thing they need to show is that their loss is difficult or almost impossible to quantify. However, we say that is the wine producer. The profits earned by a wine distributor is very different from the profits earned by wine producers. And hence, we say that the claimant in parallel immediately started to contact other top vineyards and managed to make substitute arrangements for the 5,500 bottles. And in their statement of claim, they have customers left. However, in that case, the tribunal held that the expert opinion from the German-Dutch Chamber of Commerce was sufficient in establishing the claimant's loss.
To the Mediterranean Wine Association so that it could do its expert report.
Mr. Bourne, the Mediterranean Wine Association would not require documents from the respondent. This is because we are requiring that this expert quantify the claimant's loss and not the sentence states, I doubt the respondent had a very specific view on the clause. Now, we see there was no transfer, there was no information that shows the claimant's intent.
You're saying we would lack that authority?
Mr. Bourne, in the event that parties did not hit the clause, no discovery shall be allowed. The agreement that proceedings were to be conducted in accordance with international arbitral practice would also
I think you'll all agree that it has been a case of 4 excellent advocates in front of 3